So our next submitter is the trustees of Judge number 2 trust. We have Mr. Stuart Ryan online. Can you see and hear us, Mr. Ryan?
I can both see you and hear you clearly. Thank you, Commissioner, and tēnā koutou katoa to you all and submitters.
Well, we can see and hear you clearly, so we'll hand over to you for your submission. Now, we did receive this yesterday. I've had a quick read of it.
You have a printed copy, would anybody like?
Yeah, we might distribute a couple of printed copies. I'm quite happy for you to read your submission to us in full, if that's what you'd like to do, or you could just take it through it and highlight particular areas where in your land.
Yes, perhaps if everyone has a written hard copy, then I can just simply speak to key points to give you the general thrust or scheme of the submission. And should I wait a couple of minutes just till hard copies are provided, Commissioner?
It's actually not many of us here, so we're ready to go.
Oh, thank you. So look, I should make clear at the outset that these submissions, which are in relation to the treaty settlement overlay, I acknowledge at the outset, as I say in paragraph 2 of the submission, that it's acknowledged that post-settlement governance entities and also iwi that haven't settled have an understandable aspiration to improve the lot generally, socially, culturally, economically, environmentally for iwi, and that commendable objective is not in question. I want to underline that, but rather the concern of the submitter is the planning ramifications of a broad-scale exemption through the mechanism of the treaty settlement land overlay, and in my respectful submission, the implications of which haven't been fully considered, or the ramifications of such a large-scale exemption considered. My client submitter here is a private investor of land in the Kari Peninsula, so the spatial extent of the submitter's interest is more confined than some of the submissions that you've heard. However, the submitter has an eye to the future in the sense that land in the Kari Peninsula is not currently subject to settlement, but if a settlement does come into force during the life of the plan, then it's anticipated that any future plan change would simply be a mapping exercise, and therefore issues of principle or the appropriateness of the broad-scale exemptions won't likely be up for grabs. They would be out of scope on a later in time submission. So the submitter is really using the opportunity to have a say now on the scale of these exemptions before an overlay applies within the Kari area. I should say, just to help you join the dots in terms of my client interest, is that the submitter has previously appeared through me at earlier iterations or earlier hearings and has made submissions on issues relating to the use of vehicles on beaches within the far north, and also various issues in terms of coastal mapping. And the submitter's concern relate to the quality of the built environment in terms of the impact of activities on the environment, the quality of urban type buildings, and here a concern that I'll come to, that really the treaty settlement land overlay will allow for urban type buildings or urban building typology. And in my respectful submission, that creates issues of planning coherence and consistency, which I wish to explore with the panel. In terms of the scope of the treaty settlement overlay, I note the guidance notes that are effectively provided at notes 2 and 3 of the drafting. So note 2 provides for certain matters, as I understand it, like overlays will become more stringent, but within zones, activities that are provided for within the treaty settlement land overlay will effectively override the underlying zone provisions, such that, as I've recorded at paragraph 7 of the submission, the least restrictive rule would apply, i.e. there is a broad exemption. And I set out at paragraph 9, general terms, the RMA, at least in terms of how we're dealing with it at present, typically regulates activities in terms of their bulk and location and activity classification without regard to the identity of the landowner. The Act is, as currently written, its effects concerned with the effects on the environment of activities. And I mentioned that the touchstone for rules in terms of that is at paragraph 9, subsection 1, which refers to section 76(3) of the Act that says that a council or territorial authority has to have regard to the effects on the environment of activities, including in particular any adverse effect. And so the question usually is, what is it about it, the activity, that's not going to have an effect on the environment? And generally speaking, in practice, plans don't tend to differentiate between the identity of classes of the person undertaking the activity. While in theory you can still have a resource consent that's personal to the holder, that practice is never in practice applied. And in my respectful submission, it's not self-evident why performance standards that relate to activity classification or bulk and location controls, or the permeability of land and its absorptive capacity in terms of impermeable coverage, shouldn't differ between activities, i.e. if there are like activities, there should be, in my submission, like rules. And I note at paragraph 10 that the scale of departure is quite wide in some cases. Attached to the submission at Schedule 1 is a table that compares the performance standards in the TSL overlay and compares it with the open space zone and the rural production zone. And I simply note a few of the key departures at paragraph 10, paragraph 11, rather, of the written materials. So, for example, within the rural production zone, the maximum impermeable surface coverage for a site is 15%, whereas within the treaty settlement land overlay, the impermeable coverage is 35%. There are broader allowances for commercial activities. The recommendations to you appear to strike out the word small scale, i.e. the proposal is from submitters that the exemptions in the overlay would apply to large scale commercial activities. I note a proposed rule, and this I'm reading from the top of page 3 of my written materials, that the maximum building coverage for a site is 50% compared to 12.5% within the rural production zone. And I note permitted activities include 12-metre above ground structures as of right that are permitted. And so simply in terms of looking at the TSL standard 5, what does that really mean? For example, if a site's 100 hectares, does that mean literally that you could have building structure at 50%, i.e. a 50 hectare building as a permitted building as of right, provided you comply with the other standards within the treaty settlement land overlay? And that seems then to, in my submission, introduce the idea that really, when you look at the scale of the exemptions, which I've set out at Schedule 1 of the submission, that the scale of exemptions provide for urban type building typologies within what typically would be a rural production zone. So while the overlay is cloaked within a treaty settlement language, in fact, the standards in my submission relate to urban type building typologies that don't really fit within the scheme of the proposed plan and the structure introduced in terms of zoning and the national planning standards that provides for differentiating between urban, rural, and commercial type activities. And I note at paragraph 12 that typically, for example, stormwater flow controls they're not inherently an issue that's affected by the identity of the landowner. If you own land next to a rural site and the rural landowner wants to build a commercial pack house or some sort of rural activity, and the pack house generates higher stormwater runoff than a 15% standard, which is the prescribed standard within the rural zone, then adjacent landowners may potentially be affected and treated as affected persons under the existing rules. Whereas here, if you're a rural landowner adjoining a future treaty settlement overlay, which the full extent of which hasn't yet materialised because the largest iwi hasn't yet settled, then those owners are going to be receiving stormwater runoff at a 35% impermeable coverage rate, which in my respectful submission seems to be anomalous, where the general standard is generally considered appropriate within the rural production zone. Then that would indicate that general surface coverage standard of 15% would generally typically be applied throughout the underlying zone, regardless of the identity of the landowner. And I set out a number of other likely policy implications at paragraph 13, and some of this might be a bit of crystal ball gazing because we don't quite know how the Act will pan out over the next policy cycle. But the scale of the exemptions under current law would appear to establish a sort of permitted baseline where you could establish a relatively large building as some sort of baseline within the overlay, and then having established that baseline could then apply for a later in time variation to that, and that may lead to planning outcomes which council may find difficult to control. I set out at paragraph 15 that there are potentially a few more sort of broader policy or philosophical issues arising from the scale of the exemption. And I venture into, in paragraph 15, the issue of law reform. I know, of course, that at the time the PDP was promulgated, the national legislation was intending to be replaced with the Natural and Built Environment Act. Of course, that's now been repealed, and as of the last couple of days, we are told that the government is to set a bonfire on existing planning rules. Lawyers in particular have been singled out for causing difficulties with the current arrangements. I may or may not be employed or have to retrain within the next year. That remains to be seen. But we're all told that the replacement legislation will be guided by a system of property rights. And respectfully, it's not self-evident to me how council could or will in the future resist other landowners seeking to have the same exemptions. If exemptions of this scale apply. And in my submission, the settlement legislation that underpins some of the policy thinking to the overlay doesn't have any express words exempting planning rules or planning bulk and location controls or permitted activity controls as part of the rationale for the settlement legislation itself. Typically, that settlement legislation provides for statutory acknowledgements. It may have express mechanisms for some statutory boards to manage particular parts of the coastline. For example, I think there's express governance requirements in terms of 90 Mile Beach in terms of some of the legislation. And there's bespoke arrangements within the settlement legislation, but there's not, at least on my reading, any general support for the idea that settlement land should be exempt from general bulk and location controls. It's not an idea that's enshrined within the settlement legislation itself. And so the proposition that I'm advancing is really that where you have like activities that like bulk and location controls should apply in order to maintain coherence. And I've referred to Schedule 2, to a series of regional policy statement provisions that provide for the idea of avoiding incoherent development and ensuring that development's built and planned for in a coordinated manner. The issue would be less problematic if there were the adoption of a settled planning that I've referred to the submission in terms of papakainga zones or settlement zones or special purpose zones or precincts where hapu or iwi or post-settlement governance entities want to target particular pieces of land for use and development. But the broad nature of the TSLO overlay appears to be at a much broader level and is not focused in a way that would allow people to anticipate what the effects of broad-scale exemptions are. And in my respectful submission, the overlay would be better limited to an information rule so that the overlay is retained for information purposes, and it sits there as an indicator of the significance of the land to iwi and post-settlement governance entities generally. I've referred in my materials to the couple of schedules that I've attached, and those are self-evident from the materials. I've only highlighted a couple of provisions. I don't particularly wish to take you through those. But look, those were my submissions, and I'm happy to answer any questions that you may have. I appreciate, of course, that the objections raised are sort of a more policy philosophical level than the recommendations in the officer's report.
Thank you. I'll lead off a couple of questions for you. I take it your client has no issue with the multi-purpose zone?
The submission, the submission is directed at the treaty settlement land overlay. However, you know, some of the issues around the consistency of bulk and location standards could logically extend to the Maori purpose zones.
But it seems to me that you're saying that there is a potential disconnect between an overlay and its underlying zone. So I understand the logic of that. Given that the multi-purpose zone is a zone on its own, it wouldn't have that tautology, would it?
No, it's a more focused control, and I haven't done a exhaustive review of the scope of Maori purpose zones within the plan, but they appear to be more focused on existing land holdings rather than future land holdings in terms of settlement lands.
Well, I don't think the overlay applies to land that there has to be a settlement for the overlay to apply, correct? Yeah. So the TSL applies to land that has a settlement in place. It doesn't apply to land where settlements are in negotiations or subject to claims before the Waitangi Tribunal. No. So if you're seeing the council officers there shaking their heads and saying, so the proposition is that it only applies to land that has actual settlements.
Yes, but however, the idea enshrined in the overlay is that it will in time apply to future land that is identified as settlement land. So the plan provides a template upon which a future mapping exercise will occur.
Okay. So, I mean, my understanding of this approach is that a treaty, or Maori purpose zone, or treaty settlement overlay, is that Maori will use that land differently than a farmer would, somebody engaged in rural production would. That the actual activities that occur on treaty settlement overlay land are different than what you would see on a commercial farm production or production type activity. So if you accept that premise, then you would accept that the provision would need to be slightly more responsive to those different activities.
Yes, the policy at TSLP2 sort of starts out by recognising traditional activities in terms of marae, papakaina, customary use, cultural, and as notified had small scale activities. But as you know, the recommendation is to delete the word small scale and replace that with simply commercial activities simpliciter. So the idea that the overlay will be used in a particular manner in my submission is not borne out by the performance standards themselves. So the performance standards, for example, at TSLR3, which is residential activities excluding papakaina, provides for the number of residential units on a site doesn't exceed 6, but the size of those units are not specified. You've got performance standards that provide for 12-metre buildings as of right, and you've got performance standards that provide for 35% impermeable coverage and 50% site coverage. And in my submission, these are urban typologies. This is a sort of medium density residential development that is the sort of stuff that is occurring in and adjacent to Auckland's metropolitan zones, where there's a significant liberalisation of performance standards, particularly given propositions that this overlay is not anchored by any idea of it being small scale.
Okay, well, thanks for that. But going back to the question I put to you is that the principle is that treaty settlement land will be used differently than rural production land. And I'm just wanting to get your comment on that premise.
Yeah.
And essentially, I mean, whether the provisions are too liberal, perhaps is another question. But the principle that treaty settlement land is to be used, will be used differently by iwi for a range of traditional and/or commercial activity is part of that principle of what would enable treaty settlement land. I mean, I just wanted to see whether you accept that principle, and then what flows from that is, well, then how enabling do we need to be?
Yeah. I can't really assist you as to how iwi or post-settlement government entities will or won't use land in the future. All I could point to is what is permitted by the rules. And
sorry, the question I'm asking is the principle that treaty settlement will be used differently than rural production, that land for rural production. That's really a simple question.
I'm not familiar with iwi's individual asset management plans or that sort of thing. But if iwi wish to establish residential activities that provide for 12-metre medium density buildings and those site coverage requirements, then there's no restriction on doing so in the future.
Yeah, I mean, I think the height limit in the rural production zone is 12 metres. 12 metres is the height limit in the rural production zone. So you can have glass houses, barns, sheds, storage sheds, and that height. Now, I think they control the lines differently, correct? In rural production. Anyway, I certainly we had the rural production here not so long ago, and we had some discussion as to whether 12 metres is needed. It's put to us that certain types of rural production do require 12-metre buildings. So that's not more enabling, I think.
Yeah, I mean, you've got issues like grain silos and those sort of traditional rural activities that one could expect, or very large sheds. But those activities are also confined by the site coverage rule and the impermeable surface rule, whereas the TSLO overlay is not so similarly confined. And so what can we expect? That's the question in my respectful submission, that the implications of that have not been engaged with.
Yes, I mean, I think we're at the rural zone areas. We've got 6 rural zones, but certainly we spend quite a bit of time and quite a lot of submissions on the point of having an impervious surface control even in a rural production zone. Why do you have a building coverage control? Why do you have an impervious surface control, particularly in rural production zone and the horticultural special process, etc. And we're grappling with that question now as a panel. And I think you've raised a very important point, because sometimes you're before you get their site, and then you can say 15% impervious surface. Well, that's effectively a small town, potentially on the site. So we're grappling with that question, and it might end up resolving for your client by virtue of us making a finding with regards to impervious surface controls in the likes of rural production zones that is a collective. So I'll just sort of put that out there to you and convey that back to your client. We're grappling with urban type standards in rural production zones as part of another thread. And it seems to me that that was sort of quite a key part of your concern. I say, wow, if you allow 15% of rural production zones, then 50% of it's 40 hectares site, 20 hectares of impervious surface.
Yeah.
You get to the point where it goes, no one is ever going to create, but a permitted standard is a permitted standards. We're grappling with that question of impervious surface.
Yes.
In those types of zones already.
Yeah. But a couple of observations just on the stormwater issue. Of course, the current Act preserves the common law. So Section 23 says nothing in the RMA affects the existing common law rules. So you've got nuisance. The law of nuisance does regulate matters. And if people exceed the 15% in the rural production zone, you've got a current breach of a proposed rule. But if that rule was to disappear, people would still be able to rely on the law of nuisance, and people would have remedies in the district court or the disputes tribunal or whatever. But more broadly, in terms of sort of how you manage these sort of performance controls, and I'm sure members of the panel are familiar with plans which are quite permissive, and I had one not so long ago in Wairoa district on the east coast, and some of the rural zone provisions there are quite permissive. In fact, I don't think there's any height standard in the rural zones. So theoretically, you could have 100-metre story building in the rural zones of Wairoa. It's one of those very liberal plans. But of course, there's no market demand for a 100-metre apartment building in Wairoa Township. Maybe Mahi Peninsula, maybe. But you will know that within parts of the far north, there's land that is highly sought after, desired, and therefore people can be anticipated to maximise the building envelope if there is the opportunity, and that's the issue.
Yeah, I've had experience with some of those permissive areas too, and the argument that gets put back is, yes, sure, you could build a 100-metre building, but you're only allowed to build buildings associated with rural production. So you can still run into non-complying activity for a farmer, but you'd be a pretty silly farmer if you had a 100-metre high grain silos. But look, I think again we're grappling with those sorts of questions again. As I say, it's part of our rural zone deliberation. And I think your legal submissions is how to sort of highlight some of those issues. I don't think I have any further questions now, but I'll go to my other commissioners to see if they have any questions for you.
Kia ora. Thank you, Mr. Ryan, for your verbal presentation. I just had the one question around the wrap-up of your submission, where you make reference to a treaty settlement land overlay to be limited to an information rule overlay. So my question is, because as an FYI, it's pretty much a non-statutory, so it's there to be considered, no doubt. So how can an FYI layer work for an applicant to respond to treaty settlements? Would you be able to comment on that?
I can say that at least on contested applications that are still going through the Environment Court, that the Environment Court, in terms of the current legislation, is cognizant of treaty settlement goals and aspirations for iwi. And so that information in terms of I think that the court currently acts on the knowledge that land is treaty settlement land, and so to give you an example of that, there was a case over the last 18 months or so involving water allocation in Te Hiku, involving several iwi which were involved in promoting large-scale conversion of rural land to horticultural uses. And the court, in its judgment, which was lengthy, I don't know, 100 pages or thereabouts, put particular weight on giving recognition to the need for employment and other social and economic aspirations for iwi. So I think decision makers are cognizant of that. So I think an information rule would be consistent with what is currently occurring in practice.
Thank you. Yeah, I'm just mindful that treaty settlements are a long and onerous process, and usually those that started it aren't part of those that end it. So it goes through its own robustness, and it's a process that many of the iwi or hapu need to follow, as opposed to iwi having the ability to input on how that process might run. So just that, as you say, environment courts, case law stuff has that focus on social and economic outcomes, which is what some of that potential commercial redress is about, and the cultural has its own components of food connection. So thank you for acknowledging in regards to environment court processes, but I just wanted to sort of understand how an applicant might consider treaty settlements, whereas being a layer is something that needs to be looked at, and an FYI is probably the same, it doesn't have that emphasis to respond necessarily. Thank you, that was me.
Perhaps, Mr. Chair, maybe one clarification from Mr. Ryan regarding the bird layout. So in terms of what that might look like, might that look like the TSO that we have now without the rules and retaining the objectives and policies, which would still give management direction, or simply just an advisory?
Got a question?
Yeah, you think you would, Mr. Chair?
Yeah, so do you hear that?
Yes, I did. Thanks. There could be retained the pink overlay as indicated in the mapping exercise, but supported by a policy simply recognising the need to support social, cultural, environmental and economic development, similar to TSL 02 in terms of objectives. But beyond that sort of signalling, I haven't given further thought to the drafting exercise. But if it's going to be indicated, it's got to be for a purpose, right? There's got to be a rationale to it.
Okay, thank you very much. I don't think we have any further questions for you. So thank you very much for your attendance. I take it that
Thanks very much for accommodating me on.
I take it the stuff on the blackboard behind us is relating to submissions.
Yes, that's right.
Okay, thanks very much.
Okay,
Thank you all. Goodbye.
Mr. Chair, I think it's a good opportunity perhaps to, perhaps what I would say is maybe bookend some of the evidence that we've heard today. We've heard from Mr. Senator that the TSL multi-purpose zones, they relate to properties, to the unserviced properties from very small size through to very large ones, but not many very large ones. So bringing this, I think, into a sort of a planning discussion as opposed to a philosophical, I would probably recommend to the panel that they look at that framework as opposed to the individual standards and requirements for that. I would suggest that while there might be higher levels, it's flexible that deals with site size. The activity statuses for activity size will also temper that. What we've heard also from Mr. Sanson is that we don't want, particularly in relation to impervious services, the rules are too general, too constraining. We don't, we've got to provide this assessment of serviceability. Mr. Ryan, on the other hand, says you can do anything you like. It's very different from other zone chapters, but the difference, particularly in the impervious service law, is again looking at a framework-based approach, is that the effect of that will have to be assessed to be a permitted activity, where that requirement doesn't exist in the outputs. That's a lower threshold. It's a lower threshold. The higher threshold is offset, in my view, at least in part by a requirement to demonstrate that you can service that higher threshold. Right? There's an extra gate you have to go through before you earn that extra level of impervious service, right? So I think it's not apples with apples. I think it's apples with oranges.
And I think that we will try to go with our question. It's serving a different function. Right, no, thank you very much. That is helpful. Just sort of help me on. I know I've answered this question in my own head, but I sort of got lost a bit, so maybe you guys can help clarify. The difference, the overlay and the zone are applied, they're very similar provisions, but they apply to different types of. What is the difference between the zone and the overlay?
Is your question relate to why we chose them different?
Yeah, why are they all one zone? I saw the distinction somewhere, but I just can't find it.
So I think the distinction comes down to actually the national planning standards, which provide for the market purpose.
Yeah,
they don't provide for the treaty settlement in the same way. People we chose to.
Yeah, that's right. What's the difference? In other words, a treaty settlement overlay is in ownership by Awanui.
Yes.
Not necessarily. There will be some cultural sites, won't be tourism.
Is it because they aren't in ownership to be zoned? They can't be zoned?
No, they are titles that are in the ownership of the post-settlement governance. So, but also, and there are two different. So the Te Reo Māori Act governs the Māori purpose zone and provides us with that data to provide that zone. Yes, and then the national planning standards also provided us with that mechanism.
Yes.
It doesn't. The national planning standards didn't provide us with a mechanism for treaty settlement land. So we chose the overlay, but with a similar provisions to Māori purpose zone because we're trying to achieve the same thing.
But some of the Māori purpose zones treaty settlement land. I guess that's the distinction.
That is a distinction, yes.
Yes.
The land that was returned under deeds of settlement is general land.
That's it. Sorry, that's the distinction.
Right. Yeah.
So treaty settlement land is a result of land on treaty settlement.
Yes, and it's Crown land. So the only land that's available for settlement under.
So whereas so this land is property that's always been in Māori ownership.
Yes.
It had not been alienated and turned. It had always been there, and then where ongoing lands happen, whatever. And so that is land that's been held by Māori in perpetuity.
Yes,
versus land that has been returned to the Irish by
yes.
and it's your opinion, council's opinion, that you couldn't zone that land, no purpose, so, because that.
It's not under the ownership of, it's not covered by GDP.
Right, I also think,
It's not.
can we not resolve this issue?
Well, that's, yeah. So, it's only Crown land that's available for return under settlements, and its various forms. And, one of the settlements have been returned, conservation, land under the administration of conservation.
So some of the answer to Mr. Ryan's submissions could be that it has to be zoned something. So you have for an overlay to apply. You can only put it in this plan highway overlay. It has to have a zone. And I'm assuming it was section 77. I'll go. I had to go back and read that. You would have gone through that process of going, well, okay, it can only go one over there. What's the best zone to put it in? Then you would have gone through the actual open space. Those sorts of things that I expect.
See, the land is in a range of underlying zones, natural, well, under
And that's what
the
treaty settlement overlays apply, not just to rural production. It's
No.
just that that's not really what's present.
that's the most prevalent one.
Because that's where the big blocks are coming.
But it's,
You've got a couple of residential zones.
yes, there is a residential zone.
So we're truly going to overlap.
Yes.
See, yeah,
That's right. Natural open spaces in other large
Yes.
underlying zone.
So Mr. Ryan's primary concern is related to the treaty settlement overlay as it may relate to the production zone. That's what it's doing.
And to be fair, a major part of the settlement land, I can't remember the quantities of it will be rural production because a large number of farmers,
So and the question that I put to Mr. Ryan, do you accept the principle that treaty settlement land would be used differently than the underlying zoned division? And that's the case. Some different. That follows the structural limitations that you've got as well. You had to find a zone, like to apply the overlay to it. You can't write excessive provisions that are bespoke for the treaty settlement overlay because framework will be
I guess that's a choice we made.
But I think what you said to me before, that Maori purpose zone can only apply
To land.
not treaty settlement.
Not treaty.
So therefore you can't write a zone for it. You have to use another zone to work it. And land standards and land provides.
That's right.
Yeah. So in that sense, there's always going to be a potential tension because you're putting an overlay on something that is intended to do something else.
That's right, but other counties have approached it differently. I think Auckland made it created trees for something like that. It's a while ago since I looked at the, because we, before we did this work, we looked at,
Right.
other examples. And I think Auckland council may have created trees in themselves.
Yeah, but they would have done that with planning standards.
Yeah.
Legislation came out, and so they would possibly slip under that. Right.
Yeah.
Okay. Well, no, thank you for clarifying that. Okay, so if you're pretty commercial development, you're our last submitter. We've got between now and 5 o'clock. We are going to we are going to be bringing up one and there is one to join us. So, what I want to say is don't feel constrained by time. And
Jordan Tato. I think before I bring the presentation up on screen, I'll just sort of introduce how we'd like to present if that's okay, and if that's acceptable for everybody. So I'm here to invite people to look at the presentations, but a part of my presentation does touch on elements of Te Awapore's government structure, their strategic sort of elements that they're trying to achieve as a post-settlement government entity. And I would just like to indicate, and just make sure that's okay, that when those slides are up on screen, if it's okay, if we both comment on.
Of course, look, I think we're allowing to present your evidence in the way that you see fit. If you want to summarise things, that's fine. Obviously, we've read the expert evidence, but if you want to present something else or further detail, you have to step through.
Excellent. I might, in the first instance, hand over to Tina to introduce South and Te Awapoe.
Tēnā koutou, tēnā tātou ko tīwhene kapakini ahau, te pau whakarai, te hunanga nui o Te Awapoe, he kauri hoki ahau, mo te whānau kapa, he te pātū hoki, mo te whānau Sunnian, he heke, mo whangaroa, mo te tāhawai, he mihi atu ana ki a koutou, he hakaronga mai ana ki wā mātou take kōrero I tēnei rā. Koia tēnā. So Tīpene, the CEO for Te Hunanga Hui o Te Awapoe, which is the overarching post-settlement government entity. We are presenting under the banner of Te Awapoe Commercial Development today, which is a wholly owned subsidiary of the Hunanga. The titles aren't as relevant because what's important for the subsidiaries is important for the Hunanga and the group as a whole. So no matter what perspective or what entity we are speaking on behalf of, the kaupapa remains the same, the priorities remain the same. So please take our kōrero as touching and relevant to the group as a whole. So our Te Awapoe, the intro, I want to cover 3 points on my introduction: people, place, and purpose. So starting with people, Te Awapoe within the definition of our trust feed. The people that we serve are all Uri, Ngāuri for Tīkanui, Rātou for Tihe, ko Kōhine. So our membership is defined by our autonomous tupuna, Tīkanui, and his 2 wives, Tihe and Kōhine, and their many children, which we all whakapapa back to in this current day and age. So that's our definition of who Te Awapoe is, from our perspective anyway. According to stats, our total population is around 14,000. So 14,000 people that all whakapapa to Tīkanui and his 2 wives, and that is our membership, our theory, our tribe that we represent in this current day. Moving on to place, so our welfare of interest, e tīmata ana ki te one roa tohe, ki ngā pai, ki te one I haia e pōroa, ka heke hakararo, ki te pito o te one roa ki kahokawa, ka huri mā kahokawa ki pito kuku, ki taurangatira, ki maunga tiki tike, tai atu ki motu o pā. Ka huri mātona, ka tai atu ki te reinga o ngā wairua, ka e huri tonu ana ki pīwhane, ki kapo wairua, ka huri tonu ki hikurua, ki muri motu, ki tērā rai whenua o ngā mātua tupuna. I kuta rā te kōrero a tūmatahina, rui a tahi a tahi. Ka heke I kona I muri motu ki Waikuku, ki mō kaikai, tai atu ki Ohau, ki te waha o Pārengarenga, tai atu ki te kokota, kei te pito hakararo o Tokerau, huri ana I Tokerau, e rere ana ki Wairahi, I Wairahi e rere atu ana ki o Taipango, ki Rarawa, ki te maunga tohoraha I Haurora, koia ena, ko ngā kainga o ku mātua tūpuna, koia tēnā ko te rohe whenua o te Aupauri e tūtonu nei. So that's our area of interest, and we do have some maps within our submissions and our presentation to draw that out in more detail. The purpose of Te Runanga Nui o Te Raupauhi, the reason why we exist, is to nurture and develop all of the descendants of Te Ikanui, all of the descendants of Te Raupauhi, and to create economic, social, cultural and environmental benefits for them all, for all of our descendants, our uri, our whānau. And that's our kaupapa, that's our purpose, and it's not a new kaupapa. He kaupapa tuku I ho tēnei, I makere mai I ngā mātua tupuna. So our purpose doesn't come from yesterday, nor tua whakarere tā mātou kaupapa, tā mātou whainga. And I also want to say that our kaupapa predates the Crown, it predates the Council, and it predates any of the structures that have been introduced by the Crown, like the regional, like the district plan that we're reviewing, amending today, like the maps, plans and schedules that we are all forced to adhere to in this modern day and time. And the reason why I'm stating that our kaupapa predates the existence of the Crown and of the Council is because our kaupapa, and this is an overarching theme within our presentation and within our submission, is that our kaupapa shouldn't have to fit within the structure of the Council. The Council should fit around our kaupapa, which has been around for thousands and thousands of years, many generations. Our kaupapa is broad and bold. We cover a lot of priorities on behalf of our people, as I mentioned before. Economic development is a priority for us. We have many investments and interests within farming, fisheries, forestry, horticulture, and aquaculture, just to name a few. Social development is a priority for us. That includes home water services and housing for our people, training and development for our people so they can secure meaningful employment. Cultural preservation and protection is paramount for us. That means reviving and preserving the mana and the tapu of our reo and our tikanga. And also we do a lot of mahi in the taiao environmental space, not just conservation, but kaitiakitanga as a whole, ki uta, ki tai, on the land and on the water. So you can see the breadth of the kaupapa that we deal with on a day-to-day basis. And our aspirations in each area are bold, and the timeline that we work on is infinite. So that's to give you an idea of where we're headed as an iwi and the horizons that we aspire to. And considering the breadth, the depth, and the level of aspiration that we have as an iwi, relating that back to the proposed district plan, a proposed district plan that allows us to achieve those aspirations and be the best Opodi people we can be, as a plan that is less prescriptive and less limiting to us as we deliver on the many kaupapa that we have on our plates and ahead of us in the near future. We also want to see a district plan that's aligned with our reality and our worldview as Te Opodi, as Māori. The district plan, as it currently is written from a Pākehā worldview, which inhibits our ability to develop our assets, to develop our people, and to develop ourselves. Many of the components of the district plan don't consider how we look at the world as Māori, which means that there are a lot of restrictions that are put onto us, which are at best arbitrary from our perspective. And we have, those are detailed out more in our submission in terms of highlighting examples of what those restrictions, limiting and arbitrary restrictions are that we are referring to. And to give everyone an idea of how we look at the world, or how we look at whenua specifically, we don't categorise whenua as rural or commercial or residential. We just see whenua as whenua, and we see whenua as an opportunity. We see whenua, when we look at a big block of whenua, we don't just see a farm, but we also see a papakainga, we also see a pohanga, we also see a marae, we also see a wharenui, we also see an orchard, we also see a processing facility for our agriculture operations, and that's how we translate our strategic objectives and aspirations into the planning and leveraging of our assets, and the main assets that we do have are our whenua. And we have many projects underway, which we'll outline in the later parts of this presentation. Because we work on such a broad spectrum of kaupapa investments and developments, and we have many projects going on at any one time, the regulatory and compliance expectations and costs put onto us working through, as we work through the current district plan and council regulations, they unnecessarily add to the cost of capital for our developments. So for every kaupapa, we have to start at the starting line and then go through and sink a lot of cost into feasibility studies and pre-feasibility work just to arrive at a yes or no if we can carry on with those kaupapa. And now if you multiply that process across the tens of projects that might be going on at any one time, the cost of capital and the cost of investment for us is disproportionately high. I'll finish my introduction there, and I'll hand it back over to Naki. So.
Kia ora, I te tuatahi, whaitoko ngā mihi tāpua. kia koutou, ngā komihana mō tēnei kaupapanga kainaki o te kaupihera o kaipukera ki te raki. Ko ai ahau, mō makarena no te tōku ingoa he uri tēnei mō ka apahi me Ngāti Kahu ki Hamaroa. So, no konei no kaipukera. I am a planner. I am based here and as you can see, it sets out my experience. I've been working in the industry for about 10 years, primarily in Taipei in the island. And amongst that sort of work that I've been doing has been working alongside Taipei in a number of, as part of this process, but also as part of helping them gain resource consents for the various activities that they have aspired to achieve. So together we have some quite on the ground experience and examples of how the planning system does work for iwi entities and te aupō themselves on the land holdings that we will discuss today. Just at a very high level, our presentation structure is outlined on the screen there. So we'll touch on the treaty settlement itself, the post-settlement governance entity structure, the roles, functions and responsibilities of that structure. I think it's really important for you guys to understand, as Tiffany has highlighted, they have broad functions, broad roles, and a wide range of aspirations that they're trying to achieve. And a lot of those aspirations are linked to their ability to fund them, which is generated from their commercial assets, so their land holdings. So we'll just give an overview of Te Aupō land holdings in the PDP zoning overlays. We'll highlight some key issues, go through Te Aupō's relief and look at some conclusions and recommendations. So obviously you guys have my evidence before you, and we're just going to highlight a few of these main points as we work through the presentation. Okay, so just on the screen here we have an overview of the Te Aupō structure, and the thing I wanted to point out here is that they're a PSG entity. They have gone through their treaty settlement, settled it in 2015. That was a long process in order for them to get to that point, and it provides an evidential basis to of all of the historic accounts of land disposition that they have had to go through. Helpfully, it also identifies all of the various land holdings that are subject to that treaty settlement, either as cultural redress, commercial redress, but also gives an indication about first right of refusal land, so future land that could be purchased and acquired by Te Aupō in the future. As Tiffany talked about, the submissions to the proposed district plan were from the commercial development entity itself, and that is a wholly owned subsidiary of Te Ranganga, Nui or Te Aupō's Te Ranganga. And as you can sort of see there, it sits below it. It holds ownership of all of the commercial land holdings, as well as the Te Aupō Fisheries Management Limited, again another commercial entity that has a key objective to generate sustainable returns, grow and enhance the value of capital assets, and generate adequate cash flow required to meet the distribution and operational requirements of Te Ranganga. So it's sort of like it is the engine room for how their revenue is made and distributed across their various entities. On the screen here, I just highlighted their hope or their strategic directions that guide their decision making. And as Tiffany highlighted, so we've got Te Pō Tangata, and that's about enablement, empower and realise wellbeing for Te Aupō people. Pōtikanga is about cultural matters, increasing access and understanding Te Aupō's kōrero and whakapapa, Te Taio, which is about, protecting and revitalising areas of significance for Te Awanui, environmental aspect, and then economic as well, Te Awanui, around growing Te Awanai's asset base, generate wealth and revenue. As I sort of pointed out earlier, Te Awanui, the entity itself represents 14,000 descendants, so it's a big number of people that they're here speaking on behalf of, and the values that or the strategic directions that they are focused on are, to meet the aspirations of all of those descendants. They have a wide range of priorities, and they're all there to support Te Awanui whānau across a range of strategic goals, support the well-being and prosperity of their people. And again, it's just about highlighting the relationship between commercial entities and the social, cultural and environmental outcomes that they're also trying to achieve underneath other structures. So in Tipene's kōrero, he was outlining Te Awanai's rohe, and on the screen here, so we're in Awanui, so you can see Kaitaia at the bottom there, and so we're pretty much at the beginning point of where Te Awanai's land holdings are. So from here north, you'll see there that their interests start, I guess, at the south with the Opoti Forest. They do have a land holding as well in Kaitaia Township, I believe, but the majority of it is so of the Te Huku Peninsula. So collectively, they have 4,810 hectares of treaty land, 1,370 hectares that is cultural redress, and the majority is commercial redress land. And just talking about the ownership structure, so the cultural redress is primarily in ownership of Te Rūnanga, because their functions are quite clear around the social and cultural aspects of delivering their hope, whereas the economic stuff is sort of focused at the commercial entities, so that they're in the commercial redress land is in the ownership of Te Awanui Commercial Development Limited. And there's also a number of properties or land holdings that Te Awanui also shares ownership or joint management with other Te Huku iwi. On this map here, and we'll come back to it later as we talk about the spatial extent of the Treaty 7 overlay. But Te Awanui gone for an exercise mapping their land holdings that are there, so Te Rūnanga and Te Awanui Commercial Development Limited, and then overlaying the PDP overlays and zoning as well. The thing I wanted to point out that this map is quite a bit about 795 hectares of Te Awanai's land is not mapped by the Treaty 7 overlay, and it's unclear why that has happened. Potentially in the mapping area, or potentially things that the council may not be aware of. Another thing to point out is a lot of the land in Te Rūnanga's ownership also isn't mapped as Treaty 7 land, even if it was subject to a Treaty 7. So again, just something we would like to highlight.
It's just a quick question. So you'll have those legal descriptions. I've never seen something good.
So for Te Rūnanga, we did not have time to work through gathering the records of title, going back to the deed and figuring out how it's
You've given us maps of where you think.
where there's a discrepancy.
Yeah, yes. So you've mapped it, you haven't quite got the legal descriptions.
We have the legal descriptions, but we need to figure out is that subject to, has that land come back to Te Awanui through a treaty seal, or is it land that's come into their ownership in a separate way. And so that part of it is unclear. I think the frustration I've actually had with this process is it's been quite difficult for us to go through an exercise to identify their land holdings, put it over the PDP mapping. You know, that's required them to engage people, get experts to prepare these maps for them. It's a little bit of a frustration really. It should be a conversation. I think that should be happening between the council and the every entity themselves. There's only 6 of them that have gone through treaty settlement. Good way to resolve it, I think, without getting experts involved to go through that information for.
While we're clarifying this, does Te Akuri have non-purpose zone there? And so that's that mapped on these plans as well?
It is. So because of the extent of the
line.
so red is Kirura. Sorry, the other way around. Red is.
Oh, yes, I see the sort of grey spot.
Yes, that's right.
Grey spot. I see the grey spot.
And yeah, orange is Kirura. And you'll see that there's a couple of parcels that we know for sure that are not subject to the treaty settlement. But there are some parcels, for example, just in the middle there. I think it's got so the number of record title reference is 381854 on the map. Part of it's zone multi-purpose and part zone rural production, another part zone multi-purpose. So again, we're just not quite sure. I mean, that reflects that the ownership is Māori freehold lands under the G2DP of Māori Act, whereas the land that's rural production is general.
But it doesn't have a treaty settlement.
That's it.
So we've got some Māori, some just general rural zone, and then mostly general rural zone with treaty settlement over the top of it.
That's right.
And then as you say, you've got a couple of other. Do you have other treaty settlement lands that have other zonings?
There is
Other small parcels, I think there's a couple of small parcels.
yes.
in which they-
I have.
What is this next up?
Yes, so there's a number of properties that are, so if we go back to this. So the ones up in the very north tip, there are a number of properties and islands that are zoned like conservation or natural open space or something. And so that it's a mix of natural open space, rural production and as well.
There were some pieces of whenua that were brought back straight after the settlement using some of the financial redress from the settlement. But I guess that poses the question is if it's owned by a post-settlement governance entity, does that automatically make it a treaty settlement whenua, whether it was acquired during or after the settlement? But it's not an easy question, but no question and consistency.
I might say council officers can help answer that.
Yeah, I'm not
So
expecting.
you're saying it's open to land and it's treaty settlement only.
Yeah, and it's owned by a
Treaty
post-settlement.
settlement
Yeah.
overlay. I think that's the question.
Yes, and so indefinite conditions can go with district plan. Definition of treaty settlement land, which says it's property which is either vested with claimant groups by the Crown as a result of treaty settlement legislation and final deeds of settlement, or acquired by a claimant group of the Crown pursuant to the right of first refusal process, provided that the properties were specifically identified by reference to the site and time of treaty legislation. It includes cultural redress properties, commercial redress properties, including properties returned via deferred selection, properties transferred to other applicable partner entities associated or affiliated with the claimant group and properties transferred to a company in which claimant group holds a controlling interest. It excludes unspecified properties within geographic areas over which claimant groups have been awarded right of first refusal and treaty settlement legislation. Properties covered by statutory acknowledgement of deed of recognition but not owned by a claimant group. Properties in which the claimant group or an iwi hapu or whānau entity associated or affiliated with the claimant group no longer retains legal interest. Properties leased by the claimant group to an unrelated entity for a term, which, including renewals, is or could be more than 35 years, and properties transferred to a company in which the claimant group has a minority interest. So that's the definition of which we apply the overlay, and the GIS data set that we used to apply the overlay came from Te Parawhiti. In the proposed district plan that was identified in 2022, we use what I'll refer to in GIS. It's not my area of expertise, so forgive me if I use the right language. It was basically a static data set. Since notification, we have identified issues with that data set, and in 2024 we received I forget the words. Anyway, it's from Arches Online. It's basically a more a data set that is one more accurate and two more up to date, because as we know things in 2015 when the four Te Huku iwi settled, including Te Awanui, things technology has improved and things have changed, and so we've actually just gone through a process of under clause 16 to update our treaty settlement and data sets. So some of the issues that you might identify we may have rectified, but potentially not all. So I think it's something I'll need to look at now. And I know that you've identified in your submission that in my setting to our identify where that was as part of the segment. So yes, there are these potential issues. Okay. I don't think they're large scale, but
Mr. Chair, I think it's fair that it's as you're aware, there's a number of things that need to occur after a decision is made to improve errors, missions that can't be avoided through our submission for 16. This is on the list.
yeah. And I think to acknowledge also that
It starts somewhere. It starts with the data you had.
yes,
Correct.
but also to be fair to iwi partners, the process that they've been going through over the last few years has also been an ongoing the settlement process. Before you get to a deed of settlement, it's fraud, and then after you sign the deed of settlement, it's potentially more fraud. So
Yes.
they've got a hard job to do.
Yes. And I think obviously the lot rides in, whether you're in or out, being subject to the overlay means that you're this provisions and activities that you take advantage of. So we want to see all the land that's valid to be included within it, to be included.
Yes, a question of council on the clause 16, that are updating that process. Has the Te Awanui or any of the iwi that have settled, have they been a part of that conversation around updating those things? Just to clarify, things are clauses.
So the majority of the amendments that were made under clause 16 were minor corrections, and they were basically boundary adjustments because as the GIS data has improved, as the because of course post the deed of settlement, there needed to be a process undergone where all these sites that were returned were actually surveyed. So and mapping overlays, because they started off with just basically, hand maps, static images. And then as the process has been going along, Lynn's has updated those, Te Arawhiti and Lynn's have updated those, so that the majority of the Clause 16 amendments were just boundary adjustments for accuracy. There are sites that are identified that are full blocks. I think there might be 7 of them or 8 of them that we need to undertake and change because they're big, titles that have been either if they were excluded and they should have been included, then that's a clean change process, not a Clause 16. If they were included and should have been excluded, then we identified those as Clause 16, but they were clearly not. They were privately owned. They were in the ownership, not in the ownership. Yeah. Well, actually, some of them were non-landowners. Some of them were council land. Some of them so. And when we did the ownership check, if it was clear that it was not a post-settlement governance entity, and this applied to all 6 of ours, not just to the 10. Then those were made under Clause 16 because they clearly did not put the definition of treaty settlement. The ownership check identified that, so we did those under 16. There were maybe 6.
Just, I know with settlements it is Crown land, not council land. Yeah, not like council land. Council's the administrator and manager. Crown is the owner, so usually that's how that sort of stuff.
Yes,
So the things get lost on them. Right?
yeah, but there were only a couple of people each being on East Land, and they clearly still have the ownership. When we did the ownership check, it was still clearly in ownership. Because by now, because our settlements, 6 settlements range from 2008 to 2000. When was Code Articles 2018 or 19? So there's been enough time for those titles to have undertaken ownership change, and has got the new titles.
Right, sorry, Mr.
That's fine.
Picked up something that's obviously of interest to
Really cramped your style there, I'm afraid, so my apologies. So I think that was actually quite a helpful clarification. Hand it back to you, Deanna.
Thank you. I'm just gonna, I don't want to go through the detail of my submission, but there's something I do want to point out, and this all leads to, I guess, the relationship between the overlay and the underlying zones. Sort of, we've been talking about it a lot this morning. And as I worked my way through the Section 32 report, and I agree with it, they have identified, I consider that the Section 32 report did identify the correct statutory planning framework relevant to Māori and treaty settlement land. And one of the key conclusions I think I want to highlight to everybody is around the highly productive, the national policy statement of highly productive land. The point I want to make really is that for treaty settlement land, less than 1% of highly productive land is treaty settlement land. So one of the key, I guess, is productive purpose of the rural zone is all around. It's not just about protecting climate, it's about highly productive soils. We always have a range of other things to achieve, but so you picked up on it this morning. They fundamentally, so the treaty settlement land overlay, the general production, rural production fundamentally have a different purpose. And they also have a different statutory framework on what they've been promulgated for. And so the issue that we've found is that by inherently linking the treaty settlement overlay to the underlying rural production zone, it does hamper the way development can occur within the treaty settlement zone. And as I've said out in my evidence, I consider that the amendments that we've recommended ensure that the provisions do actually achieve the intentions and purpose of the overlay, while also being more appropriate in managing that relationship between the rural environment and the tree settlement.
So you saw the interaction I had with council officers before, where we were talking through, how the treaty settlement could only be an overlay, and it needed to be attached to a zone. Can't write a treaty settlement land zone. So council been wrestling with that, and so there is going to be a tension. It seems that if we accept that, and then there is an piece that we have to resolve. And I suppose that's what you have a question. Did you hear the question I put to Mr. Ryan? Which is, do you accept the principle that treaty settlement land can be used differently than rural production? And I think you say different purposes, different functions, and I added in your evidence, where you said, you're guided by Māori worldview, and that's something that we need to consider as well. That rural production zones governed by non-European economics, and you've got Māori worldview to wrestle with as well, or to guide you. And it seems to me that what we are dealing with here is a planning structural issue. The planning framework is set down in legislation. We have to use the tools that in the way that they told us to use them. So I think that's sort of the nub of the issue, isn't it? We're trying to make an overlay work through a zoning framework which is quite different. And there are a lot of similarities and consistencies. There are some jagged edges there that are trying to reconcile. Would you agree?
Yes, absolutely. I think that is the number. Just a comment, if I may, on that conversation around overlay versus design. I guess fundamentally I have a difference around whether treaty settlement land could be treated as a Māori purpose zone. I know in other districts they have wrapped it up in a single zone rather than an overlay, so these tensions don't arise. They may be, old zones that happened, prior to the
prior to planning standards.
Possibly.
We had a legal challenge put to us in the last year, which fundamentally challenged that there are really strict criteria for special purpose zone. So you've got a list of zones that you can use. This doesn't put any of us. So if you're going to zone it, you're going to have to choose special purpose zone. Planning framework, planning standards, really strict criteria. If you're going to, special purpose zone, can't put anything else. And then there's the whole question of precinct, but I don't think precinct resolves this issue because you've still got another line zone.
Just on that, so fundamentally, treaty settlement land and land that is Māori freehold land, or whatever category of Māori land governed or administered under Te Ture. Yes, I agree that they are administered under different legislative frameworks, but if you get to the purpose of how that land is treated within an RMF context, you only need to look at the national planning standards for freshwater management and the EPS for highly productive land, where there is the specified Māori provision, and they categorise treaty settlement land and Māori land the same. So I think there's a recognised similarity to Māori freehold land and treaty settlement land. And I think it's already been reconciled within the national direction at the moment. That national direction has come after the proposed district plan was notified, but
Are you saying that it could meet the criteria for special purpose?
in my opinion, I think it does.
Yeah, I mean, we haven't been down that path.
I know, and I no,
But it's an interesting proposition.
it is an interesting proposition. I think in this situation, I didn't bother bringing it up because I think we're too far down the process.
Well, it certainly was obviously Ryan's problem.
Possibly.
Sorry, again. Contested.
No worries. I don't know how we want to roll. Do we want to roll with this interactive?
Yeah, I mean, some submissions like really grinds their gears, and others really like it. So if you're happy to proceed like this, then I think we are too.
I'm very happy. So again, I guess the primary relief from Joe Cody was around making clarifying the relationship between the treaty settlement, land overlay, the underlying zones, and how it interacted with the district-wide matters. I guess the key point here is that the treaty settlement, the relief source was that the treaty settlement overlay provision would prevail in all scenarios. That hasn't necessarily been the outcome, but how it's been dealt with by my colleague, the reporting officer, is to go to the health and plan work section, make an amendment. I agree with that amendment. I think it's helpful, which essentially says go to note 3 where there's a same or similar, though less restrictive applies. I think it is helpful upfront as well as within.
Yeah. It makes sense to put it in a number of places. Users don't use the plan in a consistent way. Some people go straight to the beginning.
Totally. And I think there's a number of ways, helpful ways that you can resolve this. But I guess, as I've highlighted in my evidence, it doesn't really resolve the overarching issue of the relationship between the overlay and the chapter itself. So as I've sort of presented in my evidence, I think there's a number of things that need to occur both in the treaty settlement overlay to help signal to the readers what's anticipated within the treaty settlement overlay, but also a number of consequential amendments throughout the objectives, policies, and rule set as well. Just starting with the overview sections. That signalling, so we've got how the plan works. That's telling you right up front where this relationship tension needs to be resolved. But I think there also needs to be amendments made within the treaty settlement itself and also within the underlying zone to signal to everybody that there is a tension that's going to occur there and there's a different type of development anticipated within the treaty settlement overlay land. So you'll see within my evidence that I have recommended amendments to the treaty settlement overlay chapter to that effect, but also to the underlying rural production zone chapter as well. And the other thing that, and why I think this is appropriate, is because as I read the rural production zone chapter, there's also reference to other overlays within the coastal environment, again signalling that there's other things that need to be considered. So the treaty settlement land overlay objectives. So as notified, treaty settlement objective 2 is about supporting the social, cultural, and economic development of treaty settlement land, while objective 3 is about providing the relationship of Tāmata to that land. Initially, Joe Cody supported these objectives and thought that they could change subject to and the reporting officer has actually recommended a change to objective 2 to incorporate the word environmental to match, align with the pathway purpose of the Act. I agree with that amendment. I think that's helpful. But I also consider that additional amendments are required. I might fast forward here to the reliefs, the recommended changes recorded in my evidence. Again, it's about looking at it in a whole of plan, whole of chapter way. So it's taking the overview through to the rules at the bottom. So I've highlighted in my evidence that I don't think there's a need for a distinguish between commercial and redress land and cultural redress land, because in my opinion, both lands, commercial or cultural, provide the relationship of Māori to their land. My point earlier was that all treaty settlement land is Māori land. It is ancestral.
Can we just have a discussion about that? I'm really interested in the report that you've made, and I understand why you've made it from your client's perspective, because you see that land is treaty settlement land. Why you put a different label? But I'm just thinking, does that distinction potentially help those who are administering understand the relationship to the type of land? I'll give you an example that I've been involved in, where it seemed to make quite a difference as to, I was a commissioner. I'll tell you the story. I won't hypothesize it. I won't make it a hypothetical. I'll tell you this. It was the Parkery sand mining application. I was on the hearing panel, and just really quick summary. We had Tiara Point in the middle, we had Parkery Beach to the south, and Tiara Beach to the north. You had Ngāti Malaheri and what we call Parkery Whānau, who had been opposed to sand mining day south Tiara. And then you had the land north, which was a commercial redress to Tiuria Ho. And they went about dealing with the applicant in very different ways. For the Parkery Whānau, the removal of sand was an assault to their their ancestors. They were linked to the sand was part of them. Part of their identity and their culture and they were culturally opposed to it in every way, shape, and Tiuria Ho had made a commercial settlement to acquire an on-state forest, and they were looking to make that work commercially. They came to an arrangement the and say, yeah, well, we do this, depending on how better we are. And we accepted that, and we had a decision made. We made a distinction between what we applied and what we approved. Now, as it turned out, I chucked it all out. I'm happy with that decision either. But we were making a distinction between commercial settlement land and land that had, a long-standing cultural association. So in that sense, would it help those people administering the instrument if we understand that there might be those types of distinctions, or if I got it wrong stick?
I think you make it less prescriptive and you leave it to, or you allow diversity of thought across landowners, particularly Māori Iwi landowners, because we don't all think the same. And these are Alpha Cardinal, Mr. Opodi, and we can't speak on any other iwi. But for us, 10 years plus past our settlement, the completion of our settlement, it's become very clear that the lines between commercial and cultural, which made sense at the beginning of the process, are becoming a lot more blurry, getting a lot greyer, because the use of our land has changed with diversity and evolution of thought. We used to mine sand at what my ancestors did, and then we got to a point where we realised that wasn't okay, and we flipped. So we need to allow for that diversity and evolution of thought, and we need to allow for change of utilisation of whenua based on the priorities of the iwi or the hapu or the whānau in that space and time. Having prescriptive definitions and titles like this doesn't allow for those easy changes. But still recognising that particularly the cultural redress title that was designed as a protection mechanism for a lot of those pieces of whenua, particularly with particular taonga tapu status. But again, we have cultural redress properties on our balance sheet that we're looking at. We're considering developing for commercial purposes, at least partly. So flexibility with still some form of protection is, I think that would be the key in allowing for that evolution and diversity.
So is the concern that the council and administrator then go, oh, we shouldn't be commercially involved with that because it's cultural redress, not ours, that's really clear. You want to avoid that sort of.
Yeah, I think you need that power with the iwi, with the hapu and the whānau. And even I would go back through the treaty settlement. We're discussing treaty settlement overlay, and that's what we want to focus on. But we go back further, it's all whenua tupuna, it's all ancestral land, and that was taken from us, and then part of it, a very small part of it, was given back to us, and that's how it's become treaty settlement land. But that's less relevant. What's relevant to us is that whenua belongs to our tupuna at a point in time. It's come back to us now, and we look after it, but we also utilise it and leverage it for our own benefit.
But sort of getting back to sort of like the story that I told was that when the high executive principle, it may be easy to decide which is cultural, which is commercial. But is it important to at least recognise that some will be cultural, some will be commercial? Because that might understand how the EV responds. If someone says, oh, well, hey, you have really important to look for these cultural reasons, and then you go, no, actually this was part of commercial redress, and we were all against it. Would it still assist decision makers, people administering the instrument, to understand that there could be both elements? We're not saying that you have to sort of draw a line which is cultural, which is commercial. You would still probably have the authority to make that call, but I'm just wondering whether it's a benefit the instrument to recognise that there would be some purely commercial decisions made on treaty settlement land. And those people need to understand.
From a purely planning perspective, I don't do development, so if we wanted to understand, or a plan user, the council, whoever wants to understand whether something's commercial or cultural redress, they just need to go to the treaty settlement legislation. It clearly distinguishes what is cultural and what is commercial.
Well, I have to say in the Darkman example, it took us a bit while to work out why nothing on hearing two different words. And then it wasn't until that was explained to us that we actually understood that completely wrong approaches. Anyway,
But I think the point is, well,
I'm not necessarily disagreeing with you. I'm just
Yeah.
sort of exploring that, whether there's some benefit to having some reference to it. So,
I think at the end of the day, from my perspective, purely from a planning perspective, is when we're thinking about, so if we allowed ourselves to read these recommended changes, so to treaty settlement land enables a range of social, cultural, environmental, and economic development. Why couldn't cultural or commercial redress land be used to enable a range of social, cultural, environmental, and economic development activities? I think that's the thing, is it's not necessarily that distinguishing between the two different pieces of commercial redress of benefit. It's more about, by distinguishing, you've restricted the land to a certain type of use, or that one piece of the only cultural redress land provides for an ongoing relationship. But why does commercial land not? And vice versa for why can't cultural redress land also provide the social, cultural, environmental, and economic development of people?
Can I just look at that? Yes, we don't need that question. I think by way of use of just trying to recall my thoughts and writing of this, the distinction was more about acknowledging that in the settlements, this land was returned under those different, or as commercial redress, that distinction, and as cultural redress, that distinction. I take your point that separating out in that way may treat them differently. You can also take the point that the ongoing relationship of dealing with the Māori Tangata with their land is the reason given for the redress doesn't take away. But I do know going through and looking at the settlements, also some of the cultural redress lands, they come back with more constraints anyway, more ownerships that are under reserves acts, things that are going to constrain them anyway in terms of development. And my question for Te Rapa, the commercial development, would be I take it that the cultural redress land that you might be looking at developing in a commercial way would only be land that you'd be able to sole ownership of, and not any cultural redress land that you co-own. What about other EBN? Because there was that land that's been returned to multiple.
Yeah, that's quite. Yeah, that's very much off the table in terms of commercial development, but it varies from every block of land is a different story and plan for each. And even another point to add, even if like Judy or Ho did, when they set parameters around that commercial operation, even if we are using cultural whenua to derive a commercial benefit, we're doing that in a tangata whenua protective way. So I think that the assumption here is that commercial is damaging, is always going to be damaging to cultural, but the way we do business is quite different as tangata whenua, because it's just as much our priority to look after and protect the asset or the whenua, which again supports the point that the delineation of the two isn't that relevant, especially at this point in time.
Thank you. Thank you, Ms. Carlton. Anything else?
I just did. Thank you, Tipene and Macarena, providing a response in regards to commercial interest and cultural interest and reframing it. Because this kōrero that we're having here is pushing that thought or that pushing change from a national planning standard perspective, from a district planning process perspective. So I appreciate your response in regards to reframing all whenua is of importance. All whenua is ancestral, but of importance for various purposes, roles, functions, etc., etc. So I just wanted to thank you for your commentary around this conversation and the questioning that's happened. There's the example, Pakari Council Planner trying to get it around. It's been helpful, I think, for the kōrero that we've given back. Round settlement land has its own processes anyway. But going forward, the outcomes and aspirations from Iwi and Hapu, you have a strong direction with the portfolio that you have, and that's looking at whenua as opposed to zone or precinct or neighbourhood. So thank you. I just wanted to acknowledge and thanks. That conversation is helpful for us as a panel as we raise the question. Chair. Kia ora.
And so with all of that in mind, I'm just going to work through, I guess, the recommended amendments. I focus primarily for today on the objectives and the policies because, in my opinion, it kind of sets the context for the other recommended changes that are come to go through to the rules. So Te Awapariri's relief in terms of the policies sought amendments to policy 1, policy 2 and policy 3. So the amendment to policy 1 was aligning with traditional Te Awapariri social structures which comprise whānau, hapu and iwi, and allowing an opportunity to consider iwi's plans and strategies that they have outside a district plan when they're making an application to the district council under these provisions. Policy 2 sought the removal of small scale to ensure there was an appropriate level of commercial development enabled and provided for treaty settlement land overlay. And then the amendment to policy 3 was around removing references to the underlying zone to ensure the use and development of treaty land as appropriately enabled. So I guess trying to decouple the purpose of the treaty settlement land overlay from the underlying zone and leaving it, I guess, as I work through it, I think it's like we decouple it, but we leave it to the respective development standards that have been put forward as part of the proposed district plan. So for policy 1, the recommended amendments, Te Awapariri's relief sought to enable the occupation, use and development of treaty settlement land in accordance with iwi hapu whānau aspirations and whānau aspirations and outlined in their plans and strategies. So one of the, as we've heard here today, a lot of what Te Awapariri is doing is about their whānau at the bottom. They're an iwi entity, but it's about whānau people at the end of the day, and all of their strategies and plans are around supporting their whānau. As I sort of set out in my evidence, I accept that whānau is not really a term used often within the RMA context, so I accept that maybe it's not appropriate. Iwi and hapu are. So iwi and hapu are commonly used terms within the RMA, and I consider it still appropriate to use them within the district planning policy context. And just to link it all back to, I guess, hapu and iwi plans and strategies. So we have these documents that are sitting outside of the plan, the iwi documents, they're doing things that they need to. But you've also got provisions in the proposed district plan that talks about providing for this link of hapu and iwi plans. That sits in the tangata whenua chapter. So there is a higher level sort of direction set by the proposed district plan that says consideration needs to be made for iwi hapu plants. And in my opinion, when resource consents may be required, I think it's helpful to bring it forward to be overlaid to assist when a resource consent is required. So again, to provide that full picture to resolve those issues that we talked about earlier around, is it appropriate to develop cultural redress plans for specific purpose? Hopefully, the plans and strategies will help a land user understand why possibly done the development and insertion. Again, so Te Aupai's release sought to remove small scale. The reporting officer has recommended deleting that term within the Treaty 7 overlay chapter. I agree with that amendment. I agree that it kind of isn't needed. The provisions themselves help manage the scale and size of those activities. And it's really important to help resolve this tension between the Treaty 7 overlay and the underlying zone, because what the rural production zone says is a void. It says avoid commercial and industrial activities. So if you have an avoidance policy in the underlying zone that says, no, you can't do these things here, and you have this enabling framework that sits on top of it. But if you don't comply with whatever that permitted standard is, and default to a discretionary activity, you're going to have to go back up to both policy frameworks. How do you resolve that tension between an avoidance policy, which is very clear, and how we're supposed to achieve something, and possibly something less directive that says, as notified, that says, please, we remove all bit of track changes that says provide for use and development of Treaty 7 land. While it's very clear that what provide for the use of Treaty 7 land is quite different to avoid commercial activities, industrial activities, and rural production zone. In my experience, when you're trying to resolve that tension, you see an avoidance policy, you're not going to, that's not going to trump it.
Unless you have a provision in the overlay that says protected blah blah blah.
Yeah.
It does not relate to blah blah blah.
And actually, that is something that I thought of afterwards. And it could sit in the overlay or it could sit in the rural production
Protected
zone.
one does not relate to commercial development.
Agreed.
That's one way of getting wriggling out.
Totally.
Because you've also got that other note in there saying that the provisions of the overlay apply, and whether that relates to the objectives it can't, but you can sort of that would add guidance to some of the mystery and finding that tension and how the rules reference some policies as well. But if you have something clearly written into those provisions that says this avoidance policy may apply to commercial development, Treaty 7.
Agree, I think that.
Because if someone wants to propose something, they'd love a provision like that. Right? That's the point of what most things.
Exactly. I think that would be really powerful. Like,
Yeah, I mean, I think what we've all acknowledged today is that there is going to be some tension, and we just have to try and manage that. It's a structural planning framework tension that we have to develop.
And so just for policy 3, there's a couple of points I just want to point out, and Te Aupai's has, and I agree, like I've recommended that clause A and clause C of policy 3 be deleted. The relief has been changed. And the 2 points I want to make here is that you had, so the underlying zones have bulk and location controls, similar to, so bulk and location controls that help manage activities occurring at the boundary interface. And so you've got 10 metre setbacks outside that help manage that compatibility issue. You may have, you've got all these bulk qualification controls that underneath zone. In my opinion, that's the most appropriate way to manage that compatibility issue. And when we talk about compromising the underlying zone, it's very difficult for me to understand what type of activity might compromise the purpose of the underlying zone.
But I think what we've done is we've acknowledged that the treaty schedule overlay doesn't fit on the underlying zoning, but you have to attach it. So it seems to me that something needs to be amended in the policy anyway. I wouldn't have 3 or 4 questions to ask the reporting planner about that sort of thing, about the executive policy provision that would be vital to be compatible with surrounding activity. We're actually providing for something that's different to surrounding activity.
What's compatible or what could compromise again is subject to
Yeah,
and our real view is the more diversification and use of whenua on one piece of whenua, the more compatible it is for our strategic objectives as the rūnanga. So we don't see a public kāinga next to a farm, next to an orchard as compromising each other. We actually see them as complementing each other.
it's potentially sufficient be as well. So,
Even compatible compatibility.
the character of the surrounding area, we're going to be doing something that might have a different character. Here I'm sort of telegraphing the question. And I certainly acknowledge that there's issues with, I think what we're trying to say here is we understand that there are issues with the policy. And that's a function of the thing that we've been discussing previously. This overlay has to be attached to the main zones.
I might move to that. For the overlay, so for the treaty settlement overlay, also I've gone through and recommended a number of changes. It was sort of like which kind of which of these way that's and like what aligns with the relevant statutory context. And one of the key things I think, I'm not sure if it has been addressed or talked about, is the impermeable surfaces. So like this whole impermeable surfaces building coverage issue. So we've talked about that relationship, but I'm not sure whether it's a drafting issue or a drafting error, or maybe I've misinterpreted the way that rules apply. But so the impermeable surfaces rule, treaty civil, rule 2, the treaty civil zone, is that the impermeable surface allowance is 35%, and then the underlying the standard talks about 50% building coverage. Just
And so we're looking at those standards as they relate to rural zones generally, because that's part of the sort of doing coverage standards and the service standards are appropriate. Given that the landholders are big. Might be more appropriate for things like residential, things like that. Certainly wrestling with that question, because it sort of sets a mid baseline that is almost fancy. Well, that's fancy. I'm not critical.
I agree, particularly in the instance of Te Aukau. So one of their plans where the sort of resource concept is outlined in the evidence. It's sort of an 1,800 hectare farm.
Yeah.
50% of that, or even advanced. It's not going to occur, right? It's not.
And here's the thing: you're restricted by what you can build. If you were governed governed only by rural production rules. You're only allowed to do rural buildings. So,
Yeah.
as I said, that's, we're certainly aware of the issues with those sorts of things.
Did you guys might have any questions for me?
I've got a couple of this left over.
Okay.
And I'm going to let my commissioners have a bit of
I might, unless there's something specific that Tim here would like me to touch on, because it's all,
we understand the relationship sort of that makes perfect sense. And your evidence is very clear. And your justification and reason, I understand where it's coming from. And changes in the effective policies, where I can see how the implemented works. One of the questions, this whole question of enablement to provide for. I just want to say that again, that's something that we're wrestling with from other areas. It really depends. I mean, for some people, a bit of activity should be provided for. For some people, it should be enabled, and it's the other way around for others. I think the sort of direction that we've been trying to get from council officers, and I think what they're going to get for us is as long as you are consistent, one term perhaps relates more to permitted standards, and the other one relates to things where you need consent. And I think perhaps there's which term they use.
I would agree with that from like a policy drafting perspective, like, provide to me means the plan provides for what you're doing, but you may need to go through it.
Yeah.
Enable to me means you have your permitted activity. Go for it.
And others think of it exactly the opposite way.
I think enable is a bit more simple and clarity being provided.
So I just want to still, that we've got that issue in our frame as well.
Eu whakaro e tīpani kia taki anga iwi e tāku o la whaihui I tu mea, ke kone te kawanata e te rato te nai ia.
Nō nahi nei anō te tāwanatanga, te rata kaka te.
Korua.
Nō nahi nei anō te kāwanatanga. O tāwa tūpuna, mai rāno, ai te porokotanga o te ao, e tauahia whiana e taimuri kapuna, e whāwai ana I ngā tono ki mo kapuna, kare ana tū, kare ana mai.
I lived in Tacoma for a while, back in '85.
Well, thank you.
And I roto I te tahi whare ex-garage, and ka hoki ki te whenua era momo mea. And that was before they started the Pakainga development, which was pretty much
1996.
very innovative and compared with what other iwi hapu haven't been able to develop in this time now through council processes, etc. So, yes, no maharau time. I remember when there were people collecting lupins to plant, forestry trees and old tāne we collected them in plastic bags and bags to, bring in income. And then the pine forest and all the things that happened there. So, all along, like you have in Te Raroa, we picked the kaumata decided they had to drain, so they hand drain tangomi. And likewise in Te Kao, where the tupuna there decided to again hand dig those drains for drainage, etc. It seems to be a lot of innovation and the strength behind it was their own nature. That concept of the marae, that they had to fix it themselves. Um, you know, I suppose I'm going back to, you know, what they were doing back then. Back then, and then, you know, recently they've had the school, the Takao school, where they wanted that changed because the three schools in Aotearoa and the 75 or so Benson report that retained Te Reo Māori was in Ruatoki, Ngātihine and Takao. And the 70, but by the time I got there, there was no Te Reo. And then, you know, it took some of the members of Te Aupōuri to change the status from the state school to Kura Āki. So, I suppose, do you think that that it is only the drive of the Te Aupōuri people that will see the improvements for Aupōuri? Have you sat there waiting for the Crown or the council or anybody else to deliver what had happened?
No, it's our responsibility, and as I loosely expressed in Māori before, it's an intergenerational responsibility that goes back to the beginning of time, predating the presence of the Crown and of the council, and the development, the oranga of our people should only ever be driven by Te Aupōuri. The Crown, the council's role goes back to the Rubu debated for enabling. And so we need to be in an enabling environment to pursue our tūmanako, our aspirations for our people, and particularly in our post-settlement era, and then going right back to the signing of Te Tiriti, the relationship between Te Aupōuri and the Crown, and the environment we've had to work with, which is predominantly being controlled by the Crown, has not been enabling. It's been quite the opposite. So these changes that we're discussing today are effectively flipping and changing, transforming the environment that we operate in so we can be our best Aupōuri selves.
Sorry, and another one with the housing development that's proposed by Ngāti itself. It's, you know, you're developing houses up there in Takao, more housing. And, you know, back in the 50s, there was the urban drift. When you bring whānau back, you know, like I can recall, there were only a few people living in Takao, you know, but there seems to be more coming back, but only if there's provision for house.
Yeah.
Or, you know, there's some that are waiting to come back, but they're no house. Do you think that, oh, I think that I shouldn't ask, but do you think that will help in the building of Aupōuri security?
Yeah.
Those who want to leave the cities because it's so expensive.
Yeah, there's definitely a reverse urbanisation happening in these current generations, and we are providing for that partly with these new accommodation options, with these new flooding, but also we can't just build the flooding without also building employment opportunities, training and development opportunities. We can't just build the flooding without bolstering the social and order services within the Hokainga, and also within the Papakainga context and the way of living that we're trying to provide for our people that come into these Papakainga. We need to invest in the cultural capacity and capability of those. And that's education, so that's kohanga and kura. That's also providing space, a marae, a whareru for our people to practice their aupōritanga and live out their aupōritanga. So that's just one live example of how everything we do is connected, and we can't isolate housing, agriculture, horticulture. We can't look at those things in silos.
TPNA, in your statement, evidence of the court, you made reference in regards to the Platanta, and you outlined the Moi Korahi Pakaina, and them dwellings recently got the consent granted. Then what I wanted to ask, and I asked this question earlier this morning, the Tapuai planner, was how was the process, and hopefully Makarena will be able to respond as well, how was the process applying for your consent for that particular public owner? So just trying to understand, was that resource consent as simple or was challenging, or just the navigating of it? And to add to that question, which I did this morning, is council has in their relationships between spatial layers, development areas. Development areas make reference to structure plans, outline development plans, and as our people tend to be long thinking as opposed to just the next so-and-so, if you could just communicate your resource consent process to have got what you did, and any commentary around this potential development areas, opportunity maybe, or challenge, or whatever it may be. She did the consent.
I might go to develop. Do you mean development areas as a planning tool?
Yeah, that's
like
what
a
yeah.
a layer.
I don't know. That's a question I have to ask the council team, because there are no triggers that I could see that, to initiate a development area. So that's another question I'd have the council in regards to development areas of structure plans or master planning. Some of our people might even with the big large land blocks, master plan, and I heard this morning from Tapuai Tahi that they have a 30-year plan and they've got the 5-year strategic plan. So they've broken it down, but they had a sense of what they wanted to do at a high level, and could that be involved into a master plan, a development plan for the big large land blocks. You have, as you say, these stations for various purposes, or you have mining land or settlement land elsewhere for various purposes. Yeah, so
it's not necessarily incidents of one master document, but it's
site specific.
different spaces. But we can actually do that sort of all together into a site specific master plan.
I think as a planning, so like a layout tool, zone or a layer of specific provisions. I've seen that used elsewhere, and it's all about, but you have to have done work first too, and it's not done the work in what TPN's talking about. It's the planning evidence. And you've got your site suitability reports, you've got all your various technical reports to support that, and unless you're doing something of scale and all within the same location, it's probably not useful. And in the case of the treaty settlement and the treaty settlement, as I said before, these parcels or these land holdings are vast. They're, we're talking about 1,800 hectares blocks, and even in the time that I've worked with Te Awanui, which is about 3 years, the use of that land has changed and developed as they are implementing their economic development aspirations. An area that was a farm previously now has a reservoir on it. So we talked, I think one of the submitters earlier talked about a environment court case about, and TPN has talked about before, the Te Awanui aquifer cases they caught up in environment court. They've had to go out, they've had to leave that process to the side and try and source that water into a build a reservoir. This is a multi-million dollar investment that they've made to enable their horticultural activities. So I think it's like when we're thinking about what is going to happen here, we have to think about it for all treaty settlement land on these very large scale blocks, and they are using this land in a way that achieves multiple things. The one area, 200 hectares, that's set aside for horticultural activities. They've planted in the time that I've been working alongside these guys, I think it was 300 hectares of plantation forestry. But also we've come up, they've sought a consent for 30 papakainga units, a cultural or a community hub facility to support that papakainga, as well as a kohanga reo for 20 kids. And it shows actually what that papakainga development is supposed to achieve, is trying to achieve. So the development that we've just aligns with the definition of what's being proposed here. It's about multiple activities occurring on site to support the social, cultural, economic well-being of Māori. In terms of a resource consent process, it's not, I wouldn't say it's hard, but it's not easy either. And it's as easy as far as your bank account can take you. So it comes with very large costs to obtain this resource consent. To consent something like that, we're talking about, just for technical reports to get to a lodgement, we're talking about, I think it was $300,000. And while Te Aukau and Iwi generally might be asset rich, they're not cash rich. And that's why the provisions themselves need to be enabling, but also practical. If we're looking at the papakainga rules under the operative district plan, you know, there are a range of provisions that provide for papakainga, but there's this arbitrary thing that happens when it says you're allowed one papakainga for 3,000 square meters. I'm not going to go into the reasons why that doesn't work. The main one being that the Māori Land Court typically doesn't grant LTO areas or licensed occupied areas that are 3,000 square meters, so the functionality just doesn't work. But they also don't build houses, so you're not going to build one house, 1 to 12 hectares, fine to comply with the permitted activity standards. Again, that just doesn't make sense. It's not an effective or efficient way of doing either residential development or maintaining the productive purpose of the land. So it's sort of, to your points, yeah, it can be as easy as much as you can. So if you can afford to pay hundreds of thousands of dollars just apply for resource consent. It's easy. That's right. But getting to that point is actually more difficult than people understand.
It's the cost of capital that I talked about earlier, and you know, there's a risk that those pre-resource consent costs. There's always a risk of those sinking. So yeah, it's not an easy investment from the EV developer's perspective.
And why it's not the same as traditional development is that land then, you know, say somebody's going to be a developer, they're going to come along, develop some land, they invest that money, they sell that development. Iwi aren't selling this development, they're neither Māori landowners. They're coming up with that money, building these papakainga for farmers to live in perpetuity. And even so, for iwi, they're coming up with a range of innovative housing, ways to house their people. So it could be, you know, pathways for home ownership, it could be affordable rentals. There's all of these things that are going on in the background. But ultimately, these developments aren't being done and then sold for a commercial benefit, a capital in the way out. So thinking that, say, $500,000 to establish feasibility or something, that's risky for an entity that isn't going to be making money necessarily from this development, but also might not have a lot of cash and capital upfront to go through that process. So it's really important to get provisions.
Can I just ask, was that a notified or a non-notification?
It was a non-notified application, so it was a rural production zone. It was discretionary activity, and it was discretionary because they didn't want to abide by that one house per 3,000 square metre area. And there was two reasons why they didn't want to do that. There were two, the parcel, the record of title itself is made up of, I can't remember, about 8 parcels, different farming units. There were 2 parcels at the southern part of the site that they wanted to dedicate to public highway development. From Waikoroha, it was an old part where Te Autau Tupuna used to live. And the whakapapa why they wanted to go that way was that it used to be lived on by their people, it used to be a place of living. So let's return to that place of living to, continue what our tupunas did. And so because they didn't want to do this whole 3,000 square metre activity to be a controlled activity, they wanted to do something that was more dense. But
Then triggered the DA.
intrigued the DA because they wanted to do a court. So, there's lots of reasons why you would need discretion.
Yeah. Right, thank you. Just understand your navigating of that process, so thank you. Sorry, I've got one more question. Oh, you made reference, that's right, you made reference to management plans and the relief looking at Iwi Hapu plans and strategies. In the Tangata Whenua chapter, it does make reference to management plans, Iwi Hapu environmental management plans that are lodged with council. So Te Aupōuri has these strategies, they're for home, they aren't necessarily lodged with council, but it becomes I think the wording that's been suggested for relief. Yeah, there's something for us to think about. But as you say, it's making that connection at the higher Tangata Whenua and coming through the implementation and all the rules and what objectives and policies as well. So I just want to clarify that around management. Policy, I think.
Yes.
We are currently working on an MOU with Guy and his team, so probably see that as the channel for sharing our strategies and our plans with the council. We've been setting those up to then translate to things on a plain level.
Thank you for that commentary, because that, as you say, those are other conversations that are outside of this process that may make reflections on management. Thank you. That's another question for council. Thank you. Good.
Okay, well, thank you very much. I think we all probably need a break and some calories. But I think we just take this through a night lunch. You're invited to have lunch with us, if you wish. Council officers, we're conscious that giving you some, but also some time to sit down and think. You want to respond to some of you today.
Yeah, just Chair, I wouldn't mind a couple of questions, just clarifications from the podium, if that's okay.
Sure.
I do need to shoot off and pick up my babies from Pohanga, so we can
That's right. We won't be.
answer those questions now.
Yeah, sure.
Well, I note some of the changes around the language in P1, particularly occupation, and there's not necessarily a definition of occupation, so I'm interested to understand what occupation might mean on a given place for Te Aupōuri, whether that an occupation might not actually mean living on a site, or that might just be being in a place, what that might actually mean. If I put it in the context of, say, for example, like in a floodable area, and the rule is looking to allow you to occupy a floodable area in terms of health and safety risk. I'm just so interested to see whether how broad the definition of occupation might be.
Yeah, from a to-goodness perspective, occupation was seasonal. So they had one in different areas, but they're also very nomadic and transient. So occupation from our definition doesn't necessarily mean they're there 24/7, 365. But I would use the concept of a hika to describe occupation. So not necessarily being there all the time, but visiting there enough to feed that hika or that fire. That's enough to retain mana whenua status. And it's, yeah, that the movement around different areas is based on their seasons and the different sorts of kai available. And it also for us can mean working on the whenua, developing the whenua, not necessarily living there, but because of our cultural redress properties are reserves. So going out there regularly to do conservation work, that's all conservation for us as well. So very broad. That answers the question.
That's really, really helpful. Thank you, Mr. Chair. I guess very quickly, being conscious of everyone's smiling, everyone's hungry, of course. But it's sitting here, it is clear to me that we viewed through the rural zone, a whole range of, or rural zones, a whole range of areas, but it's clear that there is, Awanui district is a very diverse district, and that provisions to fit everybody is something that I think is very challenging with the current rules we have. I would just note that we are looking at, or we are undertaking a district-wide spatial strategy that will undertake or identify areas where we can provide, I guess, a sharp tool for places, people, iwi whānau potentially. I don't want to commit to too much detail, but these are mechanisms, particularly with the changes in legislation coming forward, that will probably allow us to tweak particular areas much more in a refined way that better fits the needs, recognising that the current tools that we have could be a little bit blunt. And this process obviously gives us so much scope to refine and improve. But I just signal that, I guess, there is scope coming and in the future as well. I guess I think, yeah, it's a very diverse part of the world, our little space, and the other states to acknowledge it's very challenging to
Can I just add one thing about the word compatible? The word compatible, I find that an odd word because ideally it should be good, but then it can also be limiting as well, because if you imagine a scenario of the neighbour that wants you to stay in the same place, in the same situation, the same way, because that's what they're used to. And if they don't like development, then like I've seen this in cases when, you know, sealed road may happen in one place, and then there's a sense of somebody getting uppity with their development. So I'm just sort of expressing that compatible might appeal to some, but it can also limit, because the neighbour can say, well, I don't like your development. It threatens my current status.
Oh, thanks again. It's been very helpful. This culinary backwards and forwards. I sort of I hope you found it beneficial too, sort of hearing us tossing ideas around. I think everyone, it's a credit to council officers that we had so many submissions, yet we only had 3 submitters appearing. So
Worries me.
yeah. I would optimistically suggest it's because, we're broad adoption of the provisions and 42 applicants as opposed to being able to attend resourced. So, we're all trying to work, we're all trying to make, I think really it's all been, this here is all been about trying to make this provision work as best as possible. So thanks very much for your submission, your attendance, and your
Well, so not going to.
So how much time do you guys like before you come back? Assuming you do want to come back.
Is there an option?
Stop the recording.
Thank you.
Yeah, sticky.